Hello, my name's Olurotimi Osha. I like to talk about history and I talk about world history, and of course, I talk about American presidents. Today, what I want to do is quickly talk about defamation, just clarify the difference between um, actionable defamation and mere insult. Of course, this is in the wake of the American public and, in fact, the world calling our president, Donald Trump, um, you know, put it figuratively, that the emperor actually has no clothes on. The emperor is naked. He's wearing no clothes. You know what that figure of speech means. So I'm going to clarify that, and I have to put a disclaimer out there. First of all, everything I say does not constitute nothing that I say constitutes legal advice. Right? This is not legal advice, and I'm not your lawyer. However, I'm sort of qualified. Qualified to discuss this because I did defamation while I was in law school. I loved it. I actually also wrote my independent, uh, my legal writing. You have to do that before you graduate. At least from the law school I graduated from, George Washington University Law School. My independent legal writing was on the First Amendment. So I did extensive research on this on on the First Amendment. Especially, I think I was interested in doing that because, while I was in law school, I started writing. Right, that was when I started writing, and I started getting published in the media, in papers, in journals. I started getting published. So, and I would write opinion pieces. So, of course, I was very careful. I was very interested in knowing. In being sure that I didn't defame anybody. I didn't, that my writing would not um, be flagged as defamatory. So I was taking the time to learn, and I was very fortunate that my professor is one of the nation's most prominent experts, right, on First Amendment. Um, and of course, as I said, I do hold a Doctor of Law degree, which is also called Latin is Juris Doctor, from George Washington University Law School in DC. So, of course, everybody's been saying President Trump is crazy, and so we have to be very careful. I want to discuss the difference between defamation and a mere insult. Right? There's defamation is actionable. Right? Again, for something to be defamation, uh, that falls under the First Amendment. Right? For something, uh, uh, for a statement to be considered defamation, that's actionable. Right? It can't, it has to rise above mere insult, right? So it would damage your reputation, right? You can show significant harm. It damages one's reputation. It can cause you to lose your livelihood, loss of employment, loss of reputation in the community, right? Subject you to ridicule in the community, subjects you to severe infliction of emotional distress, right? Not just merely hurting your feelings, right? And of course, the statement must be false, right? If it's a true statement, then under the law, it's not defamation. It must be false. There's an exception, and I've did an earlier video explaining the exception in terms of women, in terms of saying a woman is sexually promiscuous, e.g., saying a woman slept with the football team. Even if she did, it's defamation under the law to do that because the law applies, the defamation jurisprudence applies a different standard to women because, they're historically a vulnerable group, and it doesn't help to just continue to re-victimize women in a patriarchal society, right? So and their reputation can, in the past, a woman's reputation um, was linked, right, was in was linked, had a correlation to her ability to survive, her livelihood, her reputation, right? Because there was a time women couldn't get certain jobs, right? So, so women is, saying a woman is sexually promiscuous or has an STD, transferable STD, even if it's true, right? Even if it's true, it would still constitute defamation, right? So that's the exception. Um, but again, other than that, for something to be defamation, it has to be false. Who has the burden of proving that it's false? It's the victim, right? The plaintiff. The victim becomes the plaintiff. They're the ones who go to court to get damages, and they're the ones who have to prove that the statement is false. So, what's the difference between defamation and a mere insult? Remember, I said this before in an earlier video. The First Amendment protects insults, right? An insult is protected, unfortunately, right? Insulting people, you're protected. In terms of the president, right, they've been saying, well, he's crazy, and all that stuff, right? Uh, there's there's cases where saying somebody is crazy is not defamation. It's considered just an insult, a subjective insult. It's considered um, like a rhetorical hyperbole, right? A rhetorical hyperbole. It doesn't damage, and insulting someone is not viewed in America to damage one's reputation, right? If it's a subject, it can hurt their feelings, but it wouldn't damage their reputation. It wouldn't take their job. It won't cause them to lose their job, you know. And people use crazy as a figure of speech in America, right? I did an early video talking about how there was a time in the 90s, all songs expressing love, uh, always used crazy, right? Crazy for you was synonymous with I love you. So it's viewed as a figure of speech in many respects, right? In the American grammar, American lexicon. Sometimes even um, even saying somebody's crazy, even if they're referring to their mental state that they're cuckoo, it can be a figure, a figure of speech, right? Idiomatic in saying that, well, the person is ridiculous, right? They're silly, they're being silly. You can say they're crazy, they're being silly, or they're being stupid. That's not the same thing as a medical diagnosis, right? You're not stating a medical diagnosis of a mental illness. So it's not the same thing. Now, if you were to say that somebody has a medical diagnosis, like you say they have bipolar disorder, that's a medical diagnosis, like it's a fact. And then the setting where it is said also matters. If you go and say somebody has bipolar disorder at their job, where it can mean it can affect their performance, or it could cause them to lose their job and things like that, right? Then that's defamation. You're stating a medical diagnosis, right? An actual medical diagnosis of a mental illness. That's different from an insult, right? A subjective insult, that's a figure of speech where you say, well, somebody's crazy because they're acting silly, right? That's crazy. There's no specific diagnosis there, right? But people have to be careful. Um, uh, Funny though, there have been instances, they're rare, they're extremely rare, right? Again, it depends on the setting and the harm that it caused, right? Sometimes there have been instances where you saying somebody was crazy, right? Um, have been characterized as defamation, right? As defamation that was actionable, and that was rare because again, the setting matters, right? If you're saying somebody's crazy because even though you haven't given a specific diagnosis of a mental illness, if you're saying it in a place where it matters, right? Their stability is critical, right? Their judgment is critical, and you're saying it in a way that it makes the employer suspect, question their judgment, and they say, well, if somebody thinks their judgment is sketchy, then and it can cause them to lose their job, then that's actionable. That would be defamation, even though there's no specific medical diagnosis of a mental illness, right? So the setting matters, and then the harm, right? What harm was done? Was there harm that was done? But typically in America, people use that word crazy all the time. No harm done. Um, so again, the First Amendment protects insults, right? An insult, it's subjective insult, it's an opinion, right? An insult is considered an opinion, even though it's offensive, even though it's vulgar, right? The U.S. First Amendment, U.S. free speech, right? It protects vulgar, abuse, offense, right? It views speech as a marketplace of ideas, right? So somebody insults you, you insult them back. That's how our early justices who helped develop the marketplace of ideas, including Oliver Wendell Holmes. When you go to law school, you hear a lot about Oliver Wendell Holmes. He's sort of a controversial figure, a very important figure in especially First Amendment, right? A lot of, he was a justice in the U.S. Supreme Court. So you see a lot of his opinions, right? He has some very controversial opinions. For instance, he's the one who I remember he infamously stated that is it one generation of imbeciles or idiots is enough, right? So he didn't think he argued that people who were were feeble-minded should not be allowed to marry each other. So these are things that have gone to the Supreme Court, and that was controversial then. So there was a time, and court. I don't know if it's still the case. I don't think it's still the case anymore. But you can imagine this is what our paragons of the U.S. Supreme Court thought then. And this, of course, deals with mental illness. That I'm doing this discussion. I'm talking about mental illness because the American public has been raising, and the Congress, they've been raising the issue of the 25th Amendment, invoking the 25th Amendment against the president. And people have been saying, well, that has nothing to do with Congress. Yes, the Congress does not initiate the 25th Amendment. I've done a video explaining the 25th Amendment. The fourth section allows the vice president and a majority of the cabinet or an alternative body um, appointed by Congress through law, right? By the law, they can vote the majority to remove the president for a lack of capacity um, to carry out the powers and duties of the office of the president, right? So, but again, remember the president can counter with a declaration. So that declaration, right? It would be a statement of fact. Remember, for it to be defamation and not mere insult, it can't be mere opinion. It would have to be stated like as a matter of fact, that it's a matter of fact, or in a professional setting, or some kind of medical diagnosis, right? So if it so happens that um, President J.D. Vance, right, gets bold enough and he's able to garner, the majority of the cabinet, and they vote that President Trump has gone cuckoo, right? He's that he's basically gone insane. He has some, even though they don't have some kind of medical diagnosis, right, for specific mental illness, but they can point out many of his posts, his tweets, his actions, and say, well, he's unstable or he's delusional, like the one that he posted of him being Christ, right? People, there have been comments, and people have said, okay, he's delusional. This is a sign of delusions, right? Delusional grandiosity, some kind of malignant narcissism, something that's has to do with a mental illness, because the way he demonstrates, megalomania is not Megalomania can be a symptom of some kind of illness. They're delusional disorders. So they will say, well, this is a sign of a delusional disorder, right? And they go ahead and they write it down. Right? They write it down. Again, I'm just doing the analysis. I'm not saying President Trump is crazy or anything like that. That's not what I'm saying. I'm doing an analysis of how it can go. I'm trying to show what is defamation and what is an insult. If Vice President J.D. Vance is emboldened enough to write it down in a declaration, right, and presents it to Congress, that the president is now incapable of uh, carrying out the powers and duties of a president, and therefore he should be president. that would be something um, that's actionable, right? That's actionable. But it wouldn't be defamation if it's, if it's true, right? It would be up to President Trump if he wanted to sue. It would be up to him to be able to prove that it's false. But again, I did an earlier video talking about absolute privilege. Can President Trump sue JD Vance on that? No, because one, that Vice President JD Vance would be doing it in the exercise of official duties, official proceedings, right? And there's a different standard for public officials and public figures. So defamation does not apply to public officials and public figures in the same way, except, and that's me getting into, the specifics and weeds of, defamation law, which I don't want to do. For public figures, it would have to be with reckless disregard of the truth, right? Something fantastic. But so you see public figures suffer something, very, very different, very different standard than an average, a regular American would suffer with respect to defamation. But no, President Trump would not be able to sue for, defamation with respect to JD Vance if he were to go ahead and write a declaration to Congress, to the um, the president pro tempore of the Senate, and the Speaker of the House, that they think President Trump is not capable of carrying out his duties, because they're trying to say he's crazy or something, right? It wouldn't be actionable because they have absolute privilege, right? Even if it's malicious, even if they're lying, even, unfortunately. So that's one of the hazards you experience for being a big time public figure, a big time politician, or being president, right? So you see, so he takes you have to, it comes with the territory. Um, so that's that. But in terms of medical diagnosis, right? So you have to be very careful, and that's why actually psychiatrists have to be very careful typically. So if a psychiatrist writes a false diagnosis down, right, and especially if the patient did not give their consent, right, and if it's done under duress, right, it's actionable. Even though psychiatrists typically have qualified immunity as professionals, but if they intentionally wrote a false diagnosis, or they wrote it for a third party, because your mental health, right? It's if it, um, it's within your private, it's protected in your privacy rights, right? Those are they're specific laws protecting your privacy, right? So if you're saying you're not giving consent for somebody to get into your privacy, your mental health, that's private. It's protected by the Constitution. And so if they violate that right, and then upon that, on top of that, they go and write a false diagnosis, right? And it depends on the harm caused, like unnecessary commitment or unnecessary treatment, and it's actionable. It will constitute medical malpractice. It happens a lot, right? This was something I experienced, I witnessed was happening in the state of Maryland, right? But of course, you have remedies, right? This doesn't constitute legal advice, but there are remedies. For instance, in my case, you can always, you can always request a correction of your medical records. That's one. There can be amendments, and you can sue, right? You can sue. The license of the medical practitioner can be revoked, right? So all the places, even though they can, then they can proceed with an investigation. So you gather the information, what comes out of the investigation, and then you have a civil action. Sometimes it can constitute a crime, right? If once their licenses are revoked, they're found to have committed medical malpractice. Um, if it goes into a criminal matter and the Department of Justice decides to prosecute, or the state decides to prosecute them, they can go to prison. They can be imprisoned. So medical doctors, psychiatrists have to be very careful. There was actually a case that I saw. Um, the estate of Jane Doe versus Keene, right? 19. It was in 2024. Ultimately, it was dismissed because the plaintiff, right? The plaintiff. That's why it's called the estate of Jane Doe. The plaintiff was she had passed right before he went to trial. She'd passed, and so there's something called abatement, right? The case was abated because you know, I think the defamation, negligent defamation, it couldn't. That was how it was categorized, right? Bad faith defamation. It couldn't continue since the plaintiff was already passed, had already died. So, um, and that's why it went. It was ultimately dismissed, but it was progressing. It was actionable. It was found to be actionable, right? And this was an instance where the plaintiff, and the reason she's called Jane Doe, of course, is obviously to protect her identity. A social worker who didn't know her, who wasn't qualified to diagnose her, went to write that she had that she had MSP, right? That she had MSP, showed signs of MSP. And then he went into her medical records, and then she was defamed as being negligent and all that. And so she was able to bring suits, because this is a social worker. And one of the arguments was that, so she's a social worker. A social worker is not qualified to diagnose, uh, you know, uh, a mental illness, right? And she wasn't given consent to diagnose her, right? Although there's a counter argument that could have been made that, well, the social worker did that in she had some kind of duty, right? Because of her job, right? Because she was reporting on the housing conditions, living conditions of the child and child abuse. So she had a duty, and so she was protected through qualified privilege, right? Qualified privilege, because she had some kind of legal, moral duty, right, to report abuse that she observed. But still, she wasn't qualified to make a mental illness diagnosis, right? So you have to be very careful how you throw words about, uh, unfortunately, of course, many people are not trained in the law to know what they can say and what they cannot say, what's actionable. Uh, so again, yes, even calling somebody crazy, there have been rare instances when it's been actionable because uh, it caused some kind of harm. It caused people to lose their job. And so it wasn't a mere subjective insult, right? It was used like a factual statement and in the wrong setting. So if you go and you call your boss or you call your employee or your subordinate crazy in the workplace, where judgment is very important and everybody starts to mistreat that person, that will be defamation, right? You don't go to work and start calling people crazy, right? That would be defamatory, not mere subjective insult, right? Because it can actually bring about, measurable harm, right? Measurable harm. It can actually damage their reputation and things like that. Although the First Amendment, does not protect, hurt feelings. It doesn't really care about hurt feelings. You should be able to suck it up. But when it's very important to our jurisprudence when something impacts your ability to earn a living, your livelihood, right? Then it's a measurable harm, right? It's a measurable harm. If it costs you to have to go and pay a psychiatrist to treat you for the emotional distress. It's a measurable harm. So the law, First Amendment, the law, takes that very, very seriously. My name is Olurotimi Osha. I will do more videos and maybe look at a few cases. In discussing defamation versus insults. I'll keep you posted. Thank you.